begin by taking your view on the new fact check ruling or notification that the government has come out with. You are suggesting there's going to be a new body that is going to be mandated with flagging misleading or fake content pertaining to the central government. I want to understand from you, is this going to be the existing PIB, or are you looking at making a fresh body altogether?
Look, so first of all, Shivani, this fight against misinformation, this awareness of the risks of misinformation and patently false information was, in a sense, signaled in October 2022 when we came up with the amended IT rules. And in the amended IT rules, there were 9 types of content that were no-go areas for the social media intermediaries if they were to enjoy the safe harbor protection of Section 79. And there were 9 sections, and one of the sections was misinformation and patently false information. And there were other 8 categories, including CSAM, religious incitement. There were 8 or 9 categories of content that social media intermediaries could not host if they wanted the protection of Section 79. And it was clear that in matters of government, that given the government had all the information in its command, that there was a requirement by these intermediaries that they have expressed that they needed an independent fact checker from the government, because you cannot have an independent fact checker outside the government because they will not have the data of the government, to create a credible fact checking agency within the government that can then flag what is wrong, patently false, or misinformation. And so therefore we have notified that we will create such an organization. Now, whether it is going to be the PIB or it is going to be some new body, that is something that we will discuss and talk through and create. But what we are certainly interested in is to create a body that will be trusted by the social media intermediaries, that will operate in a manner that is transparent and credible. So we certainly don't want this to be anything like that panders to this narrative that our fight against misinformation is some attempt to free speech, which it is not. This is a clear and targeted set of measures that we have started taking last year to address the risks and dangers of misinformation and patently false information from beyond the borders, state actors, from within the borders, vested interests that challenge our objective of creating a safe and trusted internet.
Regardless of what you say, there are already attacks coming in that these are arbitrary and very, overpowering powers to the government, especially after a creation of such a body, and ultimately it will have quote unquote a chilling effect. Would you like to address those issues that are already being raised?
No, those are, sorry to say this, but they are in a sense a lazy, uninformed response to what is very carefully designed approach to address the risks of misinformation without compromising the Article 19 rights to free speech. As a matter of fact, these rules, the IT rules, explicitly prescribe that no platform can ever violate any fundamental right of the citizens of India in explicit language, including Article 14, 19, and 21 of the Constitution. This is the first time that a government has put in its rules that the fundamental rights of any citizens cannot be violated by any social media platform, regardless of whether the social media platform is a foreign platform or an Indian platform. So we have actually taken care to say the fundamental rights will never be violated.
You are also saying that it will not be mandatory for platforms to take off the content that has been deemed misleading, fake, etc. by this government body, but if they choose to keep that content online, then they will have to face the law of the land. Am I correct?
Yeah, so this I need to explain this, Shivani, because I think it is a nuance that needs to be understood. The IT rules basically and the IT Act protects social media intermediaries from any legal case. They have an immunity from a legal case. So if you are disadvantaged or you are aggrieved by a content on the social media platform, you certainly cannot today file a case against the social media platform because they are protected by the IT Act Section 79. This IT rules basically says the following: if you want that protection, and you don't want to be challenged by an aggrieved party, then you must exercise some due diligence under Rule 3. But if you choose not to exercise the due diligence and that choice is yours, then certainly what happens is that the aggrieved party should have the right of natural justice against the intermediary that is carrying that fake information or misinformation, as the case may be. So that is all. There is no chilling effect. There is nothing that the government is doing that mandates them to respond to a fact checking unit. All it says is if you choose to continue to propagate a falsehood, if you choose to continue to propagate CSAM, if you choose to continue to propagate religious incitement content, if you choose to do that, it is your choice. But then the laws of the land will kick in, and the right of natural justice to those that are aggrieved by that content will lie in a court of law. So this is very clear, and it is extremely fair, and it is absolutely welcomed by all intermediaries and indeed all stakeholders that are relevant on the internet, excepting, of course, for some opposition members who would rather have Section 66A and the emergency as their way of declaring their love for fundamental rights of Indian citizens.